Understanding our criminal justice system. This is the name of the chapter, and we are going to start the second part of this chapter. The first topic of this video is what is the role of the police in investigating a crime. In the previous video, we discussed about an incident in which Shanti was accused for stealing a gold chain of Mrs. Shinde. So that case we have discussed about that in the previous video. So with the example of that case, we can understand what was the role of the police in that case. One important function of the police is to investigate any complaint about the commission of a crime. If any crime takes place and any incident happens, then the main function of the police is to investigate about that. An investigation includes recording statements. What are the main factors? What are the main things in investigation? You have to remember statements of witnesses, recording the statements of witnesses, that the people belonging to that incident or they are related to that incident, they are saying anything, so that is recorded by the police. Collecting different kinds of evidences, right? Whatever object is found there, whatever things are found there, so used as evidences by the police and collected. On the basis of the investigation, the police are required to form an opinion. And if police thinks that the evidence points to the guilt of the accused person, then they file a charge sheet. So what is a charge sheet? Charge sheet means this is the group of documents, or this is a record in which police tries to explain that the accused person is in fact guilty, will be found guilty by the court. So in this way, charge sheet is prepared and filed by the police in the court. As stated at the beginning of this chapter, it is not the job of the police to decide whether a person is guilty or innocent. That is for the judge to decide. So taking the decision or verdict or hearing the cases, this is the main function of judge. So you read in unit 2 about the rule of law, which means that everyone is subject to the law of the land. This includes the police. Police also will work according to the laws. Therefore, police investigations always have to be conducted in accordance with the law and with full respect for human rights. Police will work according to all these kinds of laws, and police also will respect all the human beings. The Supreme Court has laid down guidelines that the police must follow at the time of arrest, detention and interrogation. Clear? So the Supreme Court has announced already that the police will work according to these laws during the arrest of any person, detention of any person, and interrogation or investigation. The police are not allowed to torture or beat or shoot anyone during investigation. Police cannot do these kinds of things. They cannot inflict any form of punishment on a person, even for petty offenses. Police cannot beat them. Police cannot punish the person, because Article 222 of our Constitution, and criminal law guarantee to every arrested person the following fundamental rights. If anybody is arrested by the police, that person has the following fundamental rights. What fundamental rights? For example, this one. First, right to be informed at the time of arrest of the offense for which the person is being arrested. If the police arrest any person, then the police has to tell the reason why he is being arrested and what is the process, what offense, for what offense. So this is the right to be informed for the person at the time of arrest. Second one, the right to be presented before a magistrate within 24 hours of arrest. If the police arrest any person that the person has to be presented, right, has to be presented in front of magistrate within 24 hours of arrest. This is the right of the person. The right not to be ill treated. The police cannot do the bad behave, and the person cannot be ill treated by the police and tortured during arrest or in custody. Confessions made in police custody cannot be used as evidence against the accused because under the custody of the police, the person can be beaten by the police, can be tortured, and under pressure the person can give the statement according to the wish of the police. So the confessions made in police custody cannot be cannot be considered as evidence in the court against the accused. A boy under 15 years of age, you have to remember, and women cannot be called to the police station. They cannot be called, only for questioning. So these are the rights provided by the constitution of our constitution, article 22, and the right to freedom. Another one, the Supreme Court of India has laid down specific requirements and procedures that the police and other agencies have to follow for the arrest, detention, interrogation of any person. These are known as DK Basu guidelines. These guidelines are, some of the points are there. The police officials who carry out the arrest or interrogation should wear clear, accurate, and visible identification name tags with their designations. Many times you have seen the policemen with their nameplate on their pocket and belt number on their belt. So this is the way in which we can identify them easily. Second one, a memo of arrest should be prepared at the time of arrest, should include the time and date of arrest, when and at what time the person is arrested. It should also be attested by at least one witness, who could include a family member of the person arrested. The arrest memo should be countersigned by the person arrested. So who is arrested, he or she has to sign on the memo. The person arrested, detained, or being interrogated has a right to inform a relative, friend, or well-wisher. So anybody is arrested by the police, he has the right to inform his friend, his relative, and well-wisher. When a friend or relative lives outside the district, the time, place of arrest, and venue of custody must be notified by police within 8 to 12 hours after arrest. So these are some points from DK Basu's guidelines for the functioning during investigation by the police. Now let's return to the story of Shanti and answer the following questions. The first question is, when Shanti was arrested for theft, S.I. Rao also kept her brother Sushil in police lockup for 2 days. Was it legal for the police to detain him? No, it was not legal. It was completely illegal, because Sushil was arrested or kept in lockup without any kind of offense, without any kind of information. So it was illegal. Does it violate the DK Basu guidelines? Definitely it violates DK Basu guidelines. Second, did S.I. Rao do enough to question witnesses and compile evidence before arresting Shanti and filing a case against her? No. S.I. Rao just listened the statement given by Mr. Shinde, and after that he went to their home, and after that he arrested Shanti. In keeping with the duties of the police as stated above, what else do you think S.I. Rao could have done as part of his investigation? S.I. Rao could ask some more questions to Mr. and Mrs. Shinde, and could think about it that no witness is there who saw Shanti stealing the chain, right, or the necklace. And he also could collect some evidences showing it that Shanti is accused, or in fact she did this offense or not. So these kinds of things could be done by S.I. Rao. Now let's take a slightly different scenario. Shanti and her brother Sushil go to the police station to complain that Mr. Shinde's 20-year-old son had stolen rupees 15,000 that they had been saving up Do you think that the officer in charge of the police station will promptly lodge an FIR? I think no. The officer in charge of the police station will not lodge an FIR. List a few factors. So some factors we can tell. For example, Shanti and her brother were not very influential people. Clear? They were Shanti was maid and her brother was also very poor person. So police will not be pressurized, or police will not be concerned about this. Clear? Second factor, that the police would try to find out some evidences and some other witnesses and some factors, after which the police could lodge the FIR. Clear? So other factors also you can think, so many factors might be there. FIR, what is First Information Report? It is with the registration of an FIR that the police can begin their investigations into a crime. The law states that it is compulsory for an officer in charge of a police station to register an FIR whenever a person gives information about a cognizable offense. Cognizable offense. What is cognizable offense? The offenses for which police can arrest the person without any information. Right? So that is cognizable. Cognizable, for example, murder, rape, dowry death, theft, these are cognizable offenses. This information can be given to the police either orally or in writing. The FIR usually mentions the date, time and place of the offense, details the basic facts of the offense including a description of the events, that what was the incident, how it was happened, at what time it happened, right? So these kinds of things are recorded in the FIR. If known, the identity of the accused persons and witnesses is also mentioned. The FIR also states that the name and address of the complainant who is complaining. There is a prescribed form in which the police registers an FIR. It is signed by the complainant. Though the person who is complaining, he has to sign this FIR. The complainant also has a legal right to get a free copy of the FIR from the police. So after that, what is the role of the public prosecutor? It's very simple topic. Public prosecutor, in the above case, the lawyer who was speaking on behalf of Mr. and Mrs. Shinde means appointed by state, means called public prosecutor. So criminal offense is regarded as a public wrong. Clear? Criminal offense, whatever, whether it is theft, whether it is murder, rape, it is against society and social values, so it is considered as public wrong. So what is meant by this? That it is considered to have been committed not only against the affected victims, means for example theft, it was not only the theft in the particular house, but it is also considered very serious for the entire society. Clear? So but against society as a whole. So do you remember the case of the dowry death of Sudha that we read about in the previous chapter? The case against the accused Lakshman and his family was presented by the state. So that is why the case was called State versus Lakshman Kumar and others. Similarly, the above case can be called State versus Shanti Hemram. So the victim, on behalf of the victim and what offense is done with the victim, then it is considered the public offense, and for on behalf of the government, on behalf of the victims, the lawyer is appointed, is known as public prosecutor. Right? So in this case is known as State versus Shanti Hemram and not Mr. Shinde versus Shanti Hemram. In court, it is the public prosecutor. What are the functions of public prosecutor? He represents the interest of the state. First thing, the role of the prosecutor begins once the police has conducted the investigation and filed the charge sheet in the court. After filing the charge sheet, the role of public prosecutor started. He/she has no role to play in the investigation. Public prosecutor cannot have any interfere or cannot intervene in the functioning of police and investigation of police. The prosecutor must conduct the prosecution on behalf of the state. As an officer of the court, it is his her duty to act impartially and present the full and material facts, witnesses, evidence before the court to enable the court to decide the case. So this is the main function of public prosecutor. In the next video, we'll study about what is the role of judge and the rest of the topics. So till now, whatever we have covered, you have to revise and read from the textbook. Thank you. Have a nice day.